Welcome, everybody. Thank you for being with us this morning for that webinar in association with ENVOY. I'm Catherine Le Yawang, the General Manager of the British Chambers of Commerce in France, or Franco-British Chamber, and I'm delighted to come a panel of experts on moving French employees to the UK, which is a very challenging theme for or subject for matters for companies. Thank you to all British people who are with us this morning, because it's 7:30 a.m. this morning in Britain. So thank you for being with us. Thank you, Fiona, because I know that you are in Bristol or somewhere around. Just two consignes. One, if you have got some questions and we have no time to answer it, please send it to us to the chamber or use the chat. Now I'm going to hand over to Fiona, who is going to be our moderator this morning. Thank you, Fiona, to be with us, and I'm delighted to hand over to you this session.
Thank you. Thank you very much, Catherine, and thank you the whole team at the Franco-British Chamber who've put in a lot of effort about organising this. I will introduce very briefly just their names and their subject matters, and then if they want to explain further about their firms, they will. So Antonio Lam is the director of the UK ENVOY Global, and we'll be speaking about immigration matters. Cedric Pavao from Parheli is a French tax lawyer, so we'll be speaking about French tax. For UK tax, the partner at Irvine Mitchell, Ashley Hill, will be joining us. He's doing the school run right now, so once he's back, he will be joining us. His colleague Esmat Faiz from Irvine Mitchell will be speaking about UK labour law and social security requirements, and Tristan Hubert from Evergreen Lawyers will be speaking about French labour law and social security matters. So I'm going to dive in immediately just with a couple of facts that I think are very interesting, which I wasn't even aware of actually. This week on Tuesday, Rishi Sunak welcomed the participants of the World Investment Summit to Hampton Court in the UK. France is the fourth investor in the UK. The investments are valued at France, yes. The investments are valued at £100 billion sterling. There are 81 French projects that have been started, and that has led to 4,257 jobs in the UK, which is pretty incredible. On the other hand, regarding the EU, it's interesting to note that until 2019, the EU nationals were the largest component of immigration into the UK. That's changed somewhat, but still there are 129,000 EU subjects moving to the UK. So with my esteemed panel speakers, we've decided that this morning we're going to do case studies because it makes it all a little bit more lively for everybody rather than us speaking about the nitty-gritty. And we have chosen as a case study Madame Dupont, French national with a name like that, who runs a successful IT software development and hardware procurement business. The name is Top Value in France, for clients within the EU and the UK. Top Value right now has a contract with the UK investment firm to develop bespoke hardware and software for their clients. Madame Dupont and her team are going to be required to attend meetings in the UK to understand their brief and subsequent to deliver and install the final products on client sites. Top Value today does not yet have an entity in the UK, I might say. Part of the agreement she has with the UK business is to provide aftercare service and test their products on client sites. Their presence is required in the UK, probably 3 to 4 weeks for installation, and subsequently odd days sporadically to attend any aftercare services for the next 3 months. So, Antonio, what visas are going to be required? And I'm sure that you're going to draw the distinction for everybody between work and visit activities, which is always very blurred.
Absolutely, and I think that that's one of the issues that we're facing as well. I'm not sure whether anyone reads The Guardian, but there was a Guardian article about 5 folds of EU nationals being refused sort of entry, and there was a whole bunch of stats about German nationals being turned away and French nationals being turned away and all of that. And I think that that's highly due to the fact that we've always enjoyed freedom of movement, and therefore British people would waltz into, EU, any EU countries, and vice versa, right? And we have no worries about anything at all, of course, other than employment law and taxes and so on and so forth. But immigration-wise, we really didn't have to worry much other than registrations. Things, of course, have changed, and therefore I think that needs to be defined a lot better. I mean, visitor and or business visits, a lot of people would call them. Really, it's what is said on the tin. Is what are you doing, right? I tend to use the FIND principle as an FIND principle, right? We look at the frequency of their stay. I look at the intent of their stay. So, what are you doing? Are you having business meetings? Are you just seeing clients? Are you understanding the requirements of your project and taking it back home to work? Are you actually physically doing some on hand, on the spot job? Are you filling a role? Your intent. We always look at the nature of the actual activities, what you're actually doing, and then of course find the duration of your stay. Those are all sort of mixed in when you look at is it work? Is it is it business visits? And I think that's important. So you really have to lay it out, and I find the FIND principle helps a lot, or self-defined principle helps a bit, especially for us to even look at what it is. I mean, let's look at the DuPont case. I mean, we have some key elements that we're looking at, right? We have an establishment which has no establishment in the UK. They have a contract with a UK company to provide some hardware and also install some software as well. They're helping with the business to make sure that it runs well. There are certain key elements here. So the general business rules are: you would want to look at, hey, are you going to a conference? Are you attending a conference rather? Are you just having normal meetings? But there are certain elements within permitted activities under the UK immigration rules, under the visitor side of things, that stretches beyond that and helps us to identify. And I think we are more generous in the UK in doing that. One of that is the manufacturer for goods, right? Not services, just goods, right? And that stretches a lot to not just about installation and providing installation. I think the idea previously was, you get big machinery and so on and so forth, and you have to install from different places, and therefore you have visitors coming in, but not necessarily a permanent sort of fixture in the sense of employees coming to the UK to work on those machines. So that was really designed for that. The rules also specifically in this instance, funnily enough, talks about hardware and software as well, right? And so that sort of, you can sort of identify, oh, hey, hang on, that might work. And so we probably in this instance will look a bit more at whether or not they first fit into the business case or the business visitor case. I mean, let's look at the FIND principle, right? Well, what's the frequency of their stay, right? It seems to be one-off for the installation for batch of time, which is less than a month. We're looking at very sporadic days. Obviously, we want to define what sporadic days means, right? Is it actually every day? Do you need that as sporadic, or literally it is I have to troubleshoot and come in because of the aftercare service that we have to provide? So that needs to be obviously identified, and we would want to speak to the team a bit more about that. I mean, what is the intent, right? The intent is, well, it's a business trip that we have a contract that we need to fulfill. That basically one single sort of point of intent. And what's the nature of the activity, right? I'm doing installation, right? That's basically what it is. And then thereafter, the aftercare on the other component of it. Now here, it gets a bit slightly more complex, I would say. We would want to understand the contract a bit better, right? What is the contract between you, the company, and also the UK company? So that's something, again, down to discussion as well. If the contract is very, very clear in terms of that they are supplying hardware, for example, and it is very clear also on the contract that there is aftercare service for a finite sort of period of time, this is likely to be okay. So that's something that we want to explore a bit more. There are contracts, obviously, pre sort of Brexit that has happened, and what is the intent afterwards that we need to look at. So there are some of the out of scope stuff that might need to be explored. But let's look at it as a simple sort of pure basic sort of contract. You know, do you have a clear contract, which is supplying of hardware, and do you have a clear contract to state actually what you are doing there? And if it does fit those business rules, then that realm you can then go into that realm effectively. So the contract itself is also key that we would be looking at, and of course the duration. Yeah, indeed. And so if it's absent, then you would expect that it will not just become grey and it will look like work, and therefore, do expect to be refused entry, right? If and that's the thing. And then, of course, the duration of entry, right? We know that it's a finite period of time, especially for the installation side, which is for 3 weeks, right? Again, there are very clear guidance on this, right? Which is, how long should you be here in the UK for such time? And Home Office basically would have said, well, anything sort of less than a month to do these type of installation would generally be sort of acceptable, right? And sort of less questions about it. But anything more or more than 3 months, I should say, would then be saying, well, are you actually filling a role, right? So the key here is looking at the duration here is not just about the length of time itself. It is, of course, but also, even if it is slightly longer, it's looking at, well, why do you need to be here for so long, right? So you almost, as the person who's sending your guys over or people over to the UK is, well, why are they here? Is it a vacancy that they're trying to fill, right? Or is it actually genuinely that's just one basic task that's to service or fulfill or fulfillment of a contract? And so that's the definition really also that you want to look at. But
very interesting. Very interesting. And Antonio, one question which seems to be coming up a little bit is there more scrutiny today?
See, I think people would like to say that it's more scrutiny because it's just better headlines, right? I mean, especially newspaper. My take has always been visitor has always been very subjective, right? And I think anywhere, right? But is there any more scrutiny because they are European nationals? There may be, because again, it's because of the freedom movement and now the lack of, so to speak, and therefore, the court officer has a duty to say, well, are you coming in for the purpose to which you're declaring your entry to be? And so, in a way, yes, there is more scrutiny to make sure that you're aware of why you are doing this, right? But I think, is there a target in terms of that type of scrutiny, in terms of you are that national, therefore a target? I don't think so. I think there is a mindset, and certainly I do as well, because I sometimes forget. I'm lucky. I hold dual nationality, so I can also travel to EU. But sometimes, it's sort of, I have to even think what I'm doing in the UK when I tell my clients, right? Because a lot of my clients would tell me, oh, I just came through the e-gates, nobody checks me, and that's fine. So automatically, almost saying that the e-gate itself is your provision, right? So you can do whatever you want. And that's not really the case. It's now sort of an extra layer of consideration. So in a way, there is scrutiny, but I would probably urge or almost urge travelers to self-scrutiny. And as if you are any sort of third country national.
Yes.
And I think that would be a healthy thing.
Probably, I mean, you would be also advising companies that there should be some form of checklist prior to travel, the find checklist, to ensure that they do enter correctly.
Absolutely. We work with the find principle a lot. So we talk through a lot of scenarios with a lot of companies that have, large projects and large manufacturers that are coming to the UK, for example, or those who are doing intra-corporate activities. So this is obviously one example, but there are intra-corporate activities and so on and so forth, and it can get a bit muddled. So we really do lay it down the table and basically say, hey, by the way, you need to look at that find principle, and you really need to ask yourself honestly, are you trying to fit a scenario into the visitor rules, or is it genuinely something that you're looking at? And I think that's quite important. I mean, and I think being risk adverse in this instance is better, rather than you have this huge project, you promise a client or you promise your co-workers that you're coming over and ended up being refused at port. And that's just not very nice for all rounded, right?
Correct, correct. Now, there's not only immigration that has to be looked after, a lot of other factors. Tristan, what about the social security here under this case study?
Hi all. The fact is there is an employee who is working mainly in France and will have to go some days a week in the UK to work on site. So in this situation, as this mission is temporary, I mean, we are speaking about 3 months. What we will recommend is to second the employee from France to the UK, to allow the employee to remain affiliated to the French social security. Mainly for French people, this is very important to keep their protection, which is quite high in France, and especially in the case of very temporary mission, we are allowed it by the corporate agreement between UK and France to remain the employee affiliated to French social security. So as long as the mission is less of 24 months, we can do this, and in this situation, this will be better. With the corporate agreement between France and UK, the employee will benefit of taking charge of his expenses if he's in sick leave or anything in the UK. So he will be basically fully protected. And regarding the social security, the company will only have to pay the social security in France. So this is the principle of the secondment. We can just pay the social contributions in France. So in this example, the French company has no establishment in the UK. They have basically probably no special contacts over there to pay the social contribution. So this is very easy to send the employee to the UK just for free some days a week, and to keep him affiliated to the social security in France. So the only thing you will have to take care in this situation is the employee will not be fully working in the UK. He will still work from France majority of his time, so he will be considered as a pre-reactive detached employee. So this means that he's working at the same time in several states. So he's not working fully in the UK, not fully in the France. So he's in the 2 states at the meantime. So the request you will have to do to be allowed to detach this employee is a bit different, and you will have to precise the French authorities that you are in the pre-reactive situation, and then as soon as you have requested this authorization from the URSSAF in France, you will get what we call the A1 form, which is a proof of affiliation to the social security. Very important document that the employee has to keep with him during his stay in the UK. And with these documents, you will have no any problem in the UK if you have any control from the local authorities regarding the social contributions.
Esmat, I do have one question for you, because it's interesting to try to compare the differences between France and the UK. I mean, I know that similar, let's do a sort of the similar, but going from the UK to France, the A1 form, fine. But in this case, is a shadow payroll going to be required or not at all, really?
I don't think that's actually a question for me.
Okay, fine.
Sorry.
We will. I threw that one out because it just came through my head. Sorry for
Apologies.
putting you on your toes. We will get that answer for everyone, and it will be sent. I'd like to welcome also today Ashley Hill, who has joined us. Good morning, Ashley.
Morning.
Now, Ashley, we've started on the first case study, and we've actually just arrived at the right moment because we've just got to the tax part.
Okay.
And, so this is you may have seen that the scenario slightly changed last night, and we moved it to a 3-month assignment.
Yeah.
but it was odd days a week. So are there going to be any tax implications in the UK? And then maybe Cedric could also step in and say if there were going to be tax implications in France.
Well, from a UK perspective, I'm right in thinking the employer remains the French employer, doesn't it, Fiona?
Yes, they're
Is my
on secondment, definitely.
Yeah, on secondment, and the French company continues to bear the costs of the salary. Obviously, it's not being reimbursed or anything like that by the UK employer because it's a contract, isn't it? They're undertaking. So the UK shouldn't be taxing the salary on the basis that the individual is not in France for long enough, that they're not going to be become UK tax resident if they're only there for a few months, up to a few months. So there is what we call treaty protection. The UK doesn't have any taxing rights under the double tax treaty, and the French should still have the taxing rights. And it should be the same for social security as well, I imagine. Under the if they're working in both jurisdictions, there is what we call they call what a mixed state worker, a multi-state worker. They're called if they're working in both jurisdictions over the year, and in that case, the social security NIC obligation liability remains in the country of habitual residence, which I assume will be France. It doesn't sound like they're going to become UK tax residents just under 3 months in the UK, and even if they did for whatever reason, the treaty would say they're actually more French tax resident than UK under the tiebreaker of the treaty. That all makes sense.
Yes, it does. Thank you, Ashley. Cedric, is there anything that you want to add in there? Or I know that you're going to be speaking more on the next case studies, but if there was something.
No, regarding this situation, yes, we don't have a transfer of tax residency. So we have a French employer who is paying a French employee established in France and doing most of this work in France. He's only going in the UK for a short period of time, and since it's such a short period, there is no change in how he's dealing with the fact that he still have the employer still has some tax obligation and reporting obligation. He still have to resolve the individual income taxation, but it is the same as a classic contract in France. So there is no change. Obviously, the thing would be a little bit different if, for instance, for corporate tax reason, part of the salary is borne by a UK entity, for instance, a subsidiary. But I think we will get to this case later.
Later, we will. So we've had our first case. Top value now, in our second case, they need to transfer for a period of 1 year 4 expert engineers who will be working on the client site for IT consultancy project. The service is software planning, developing, and software testing. Anthony, is that going to change anything for them? I would think so, but please explain.
I think so too. I mean, this is very different from the nature of the work in case study 1, right? Case study 1 is purely I'm fulfilling a single contract because of installation of hardware, and that is it, right? This is one sort of single task which is permitted under the visit rules. Here we are purely providing service here, right? And also, of course, if we look back at the find principle and always fall back on that, right? It's, the duration itself, let's look at it in reverse, is, even the duration itself is for a year. So it's much longer than what you would expect, right? For any visitor. I mean, general visitor, yes, you are granted sort of 6 months, in the visit installation, you're generally looking at 1 month, but here you're really almost fulfilling a role, right? So again, it touches upon very serious stuff in terms of the intent and the nature, right? Obviously, frequency of travel could be, negligible even to look at, because you have 3 other elements, which is the IND part, which squarely fits upon what I would think is purely work. The problem you have, of course, is can we just look at the standard work visas, right? So, I don't know, whether, the audience here know about, various immigration rules, but generally we would look at talk about work permits generally. And we'll look at, what we used to know as the sort of, well, we still call it the skilled worker visa, right? For skilled roles where tend to be, permanent based and to fill a genuine vacancy in the UK on more than likely a permanent basis. And then you have the old, what we call the intra-company transfer, which we now call the global business mobility, senior specialist worker, right? And that's a mouthful in itself. Those are really intended for organizations that has already as a base in the UK, active in trading, what we know as a sponsor license, or have applied for and been granted a sponsor license to sponsor for those particular routes. Unfortunately, in this instance, Top Value doesn't have any of that, right? It doesn't even have an establishment nor thinking about that, right? So is there a way of coming to the, well, the answer is potentially. We'll have to look at this again, right? In great detail. Again, the contract is very important. Well, what is the actual contract, right? Or the service contract itself between Top Value and the UK establishment, and where it fits in. And here we might need to chuck in some treaty agreement or trade agreement into it. And I think Ashley mentioned about treaty and trade, and of course Brexit is a whole plethora of trade agreements, not only the usual ones that we see, the GATS, the trade, general trade and services, but also now we also have the UK-Europe trade agreement. Now, does that agreement between Top Value and the UK establishment fit into that trade agreement? If it doesn't, I believe it could potentially be under Article 212, I believe, if I'm correct. Memory may not serve me very well at 8 a.m. in the morning. Then certainly maybe looking at the client site itself or the client entity itself, potentially looking at something called service supplier. So they're still under the global business mobility route, but the service supplier route for Top Value, because effectively what we are saying is a UK establishment is contracting with a French, in this instance, a French company to supply service effectively, and for some of the workers to be moved over for a finite period of time, in this instance for 1 year, I believe, right? And so that potentially we look at. So essentially, what is service supply license and route effectively allows a UK company which is contracted with an overseas provider, which is part of sort of, if the agreement is part of a trade agreement, could potentially have that registered with the Home Office and have a license to that effect, and have some of their workers to fulfill that service agreement. The maximum time generally allowed, and I won't go into the nitty gritty of or the necessity to apply for it, but certainly it will allow those to come into the UK to work for a period of between 6 months to 12 months. Now it depends on where the service agreement lies in terms of the trade agreement. So, for example, if it fits into the UK-EU trade agreement, then likely than not, the maximum time potentially being granted will be 12 months. So they can certainly look and explore that option as part of a route, not a permanent route, definitely. It's all meant to be very temporary, meant to be quite one-off in that sense, but certainly look at that route to fulfill that contract for those 12 months.
But for this, just so that we're very clear, sponsorship license is going to be required by the UK company?
Well, indeed, effectively, what the UK company is basically saying is, hey, I've got the service agreement, and the service agreement, if agreed, obviously by the Home Office, that it fits into the trade, and there is a whole big list of what can be fit into it or not, right? And if it does fit into it, it's basically saying, well, I've contracted an overseas entity to supply, and they don't have an establishment here in the UK, and they don't have any establishment in the UK, and we need these expertise to come over to the UK for a finite period of time to fulfill that service contract, and that's basically what you say. So it's really on the client side more than Top Value itself, but obviously Top Value will be able to send their workers, and so they almost have to work together to make sure that they can fulfill this sort of element of the work kind of rules.
There's certainly a lot of work between Top Value and their client.
Absolutely, and all of that has to be obviously genuine as well. It's not the case of, hey, by the way, you guys just want to come over here to work. There has to be sort of a genuine role that needs to be sponsored. In this instance, obviously, because they have software engineering, they're financial firms, they just don't have that expertise. They need that, right? It's pretty genuine.
Right.
Yeah.
Right. SMAT, I have a feeling that there are going to be specific UK labour law rules on working hours or other red flags that Top Value are going to have to look at.
Yeah, absolutely. So I think if you're looking at this kind of contract where people are working for a year and they are based in the UK, they are working in the UK, the service they're providing is in the UK, there's a very strong likelihood that they would be determined to be habitually working in the UK. And what that means is actually quite a lot of mandatory UK labour law will apply. So there's some examples which are probably quite easy to comply with, such as the national minimum wage. So that's going up to £11.44 in April. It's likely that people working on this kind of a project are probably going to be paid more than that. So that may not be too much of an issue. There's things like, so working time, as you mentioned, Fiona. So there's a maximum 48-hour working week on average over 17 weeks. They can opt out of that if they're going to be particularly busy and they're going to be working for more than 48 hours on average each week. There are daily rest periods. So the employees have to have 11 consecutive hours of rest in every 24-hour period. And each day, if they work for 6 hours or more, they have to have a rest break of 20 minutes, at least 20 minutes. And that doesn't actually change. So if they're working 12-hour days, they're still only entitled to, by law, only entitled to 20 minutes.
That sounds very similar. I'm just commenting here, but Tristan, please correct me. That sounds very similar to France in the fact that you have to have 11 hours break and 20 minutes in the day. Correct, Tristan?
Yeah, exactly. This is the same.
Yeah, okay.
So that's...
And then I think there's one slight difference in the weekly rest breaks, which is that you can either have 2 24-hour breaks in 14 days or 48 hours per 14 days. So I think that's slightly different.
That is, yes.
We then move on. So the whole of our Employment Rights Act applies. So there's all sorts of things in this. So the right to a statement of initial employment particulars. So that's the contract, but it's very specific about what has to be included. And there are penalties of up to 4 weeks' pay if you don't actually include every specific detail in that. So it's very much worth making sure that the employee has all those details. That also governs things like time off work, so maternity, paternity.
You put that, you would suggest to Top Value and Madame Dupont that all of that would be put in the assignment letter from Top Value to the employee prior to them going to...
Yeah, absolutely. So that right to a statement of initial employment particulars is a day one right. So they need that from the beginning of the employment. There's some things that must be all in one place. There's some things you can refer to separately. There's some things you can give later, but to kind of belts and braces, to cover all your options, it's better just to have everything in one letter. There's things like statutory notice periods if you want to terminate the employment, and where the reasons that you can dismiss somebody. These are all things that are mandatory once somebody is habitually working. So the fair reasons for dismissal, and what might constitute an unfair dismissal. And there's also some rules regarding redundancy payments. So it's really worth kind of, if you're doing this, it's really worth just making sure you've got all those areas covered. And there are more as well, but this is just a kind of whistle-stop tour of some of the things that would apply.
Thank you very much. Cedric, so now that the assignment is longer, would their income tax still be paid in France?
Yes, so the question in this situation would be whether there is a transfer of tax residency from France to the UK. Even for 1 year, we have to review the criteria from domestic law, and then how they would apply in the context of the France and UK double tax treaty. So in France, you are deemed a tax resident. There is 4 main criteria. If you fall within one of them, you are considered a tax resident in France. So I will indicate them. The first one is whether you have your household in France and in 1 year transfer or work assignment. It is often the case that we have an employee who still has their family in France, they still have a permanent home in France, and so they would, under the French rules, consider to be a tax resident in France. Second criteria is the professional activity. So for this one, if you are working in the UK for 1 year, you may be considered as, for this period, not working, not having any professional activity in France. You have the center of your economic interest. So it's assessed broader than the professional activity. It's whether you have investment, if you have income coming from French source, if you have French source income and it is the center of your economic interest. If it's in France, you would be considered a tax resident. And finally, we take into account the physical presence. So once again, for this one, you would be considered as having your physical presence in the UK. So you need to do this analysis for each employee. We can have a different situation, obviously, depending on whether the family is moving with the employee. And so if the salary is considered a tax resident, they will have they still have to pay taxes in France. It's a little bit more complex if he's considered also as a tax resident in the UK in this situation, because we can have tax residents in the UK and in France. And in this situation, we look at the double tax treaty between France and the UK, and we apply what we call the tiebreaker rule. So the tiebreaker rule works through a series of tests to determine which country between France and the UK has the stronger claim to tax the person as a resident. So in the UK, France Convention, which follows OECD model on this test, we consider the permanent home. If there is a permanent home only in one state, then this state would be considered as their tax residence. Once again, it's not so easy because when you're going for 1 year, you may be staying in temporary accommodation, but in some case you may have permanent home on both states. So we will follow the next rule, which is the center of vital interests. And under this rule, we would see where is their personal and economic relation, where they are the strongest. And this includes family, social activities, employment, and where assets are located. So once again, it's analysis to be performed on each employee, and we will take into account whether the family is traveling with them or not, and what are the ties that they maintain with France. Following that, if we cannot determine based on the center of vital interest where is the tax residency, we will take into account the habitual abode. It's where the person spends most time.
Most time, yeah.
In this case, would be for the given year in the UK, since he is working based in the UK.
But we've given a very simple, I mean, here are the example. I just wanted to step in so that attendees can understand that it's quite a simple case that we've given here, and that probably some of you may be thinking about transferring employees, and they could be on rotation, they could be doing 3 days a week. And from what Cedric has explained, and Ashley has also done, you can see the multiple layers and questions that are going to have to be answered. And that's going to be for all the employees, whether it's on the immigration front, the labour law, social security, and the tax. There are a lot of questions. But I would like to, because I can see that the time is moving on, as always, move into our third case, because there are a lot of questions about this that come, and especially to the chamber. and it's around interns. So Madame Dupont's top value business has actually developed 30% in the past year, and she has now decided to open her UK subsidiary. And they are planning on sending 20 intra-company transfers and sending interns as well. Antonio, very, very briefly, opening of a subsidiary, is that going to be an advantage from an immigration perspective for those who are employees?
It's a yes and no, but I also want to cover what you've just said fairly quickly within 30 seconds, what you said about the extra layers. I mean, the service supply, and I want to remind the attendees as well, not to rush into just signing contracts, because there is a specific thing about that. It needs to be an open tender or very similar to make a genuine contract. So make sure you're clear on the rules before going ahead and sign all these contracts and intending to send a whole bunch of people on 1 year assignment based on service supplies, right? So that's what I was about to say. So let's go to this case study, and I'll be quite brief about it. Again, there are several layers, more than an onion, that we need to look at, but there's a yes and no to this, right? I mean, there are routes in the UK, and I think that's one of the great things about splitting so many routes, is that there's something to fit something. Right. And I mean, here we're looking at potentially setting up, I mean, forget about the numbers that are being sent over, the 20 and the interns, but immediately what we were drawn to myself is, hey, who do you need to be sent over to the UK as a sort of first wave to set up the subsidiary, right? If it's a whole team that you need, for example, this very senior person that needs to establish the business here in the UK, and also the team that helps it, then automatically draw me to something called an expansion worker route. Again, it is part of the sort of global business mobility sort of realm of things that was created for this particular purpose. It replaces what we used to call the sole representative route, which only allow one person to come to the UK to establish this business and without a license. But now, because everything is in essence sponsored, most work routes are sponsored, this will also need a license, but it's slightly different in the sense that with an expansion worker, if there's a senior manager or somebody with a special skill that is to come in, obviously an employee of the overseas business, to come in to establish the subsidiary or the branch in the UK, they can potentially send not just one, but up to 5 people, like almost a team, to come into the UK temporarily. Now, obviously, they need to be there are requirements based on for the overseas business, but also for the UK footprint as well. So we need to show that, you know, some work has been done for the UK. It's not just a case of, hey, again, don't rush around and say, I'll just open a company and that's it, right? What have you done? Have you done a business plan that's feasible, that you're going to really establish this business within 2 years, for example, right? Have you done any sort of legwork in coming in? And I think the Chamber of Commerce here would be able to help a lot in the sense of what is the footprint, right? Have you looked for offices? Have you signed up to an office? Have you signed up to have you registered a company, for example? You know, those are things that we will look at, but more importantly, your plan of what you're about to do in the UK and what that sort of entails. And of course, the caliber of people that you will be sending over as a first wave, the 5 or the maximum of 5 people that I'm talking about to establish this. And I think that's very important to look at. Sorry, my voice is going away. Still recovering from a cold, which seems to keep coming back. And so that would be probably the thing to look at. So if there's a license, then obviously you can send these people over. Maximum time actually is granted only for 1 year to establish this. And if you need more time, a further 12 months will be granted. But in 2 years, if the business is, if Mr. Dupont is very unlucky and cannot feasibly, you know, set up this business at all, then sorry, that's the end of the road, right? However, let's look very quickly on what happens if we are successful with this, right? Within 2 years, we're able to set up and we've hired some local people and we have established this. Then we are now looking at the standard sponsored work routes potentially for these 20 individuals. Now, of course, we still need to look at, is it genuine vacancy? Is there genuine need? What are the roles about? What's the skill level? What's the salary? All of that will need to come into play when looking at that. But potentially we'll draw upon something called either the skilled worker visa, which is again more permanently based, or those who hasn't worked for the overseas business before. But in this case, we could potentially be looking at, and assuming obviously we have to look at salary and tenure of the business overseas, a global business mobility senior or specialist worker license. Again, for these transferees, for these permanent, for these long-term sort of transferees, that's what we will be looking at. Now, the $1 million question is, what about the interns? What are we going to do with these interns, right? Because we have a rolling program. Now, we'll look at whether or not, and we have to really establish this. this Ms. Dupont and her company in the UK overseas have an established graduate trainee sort of program, right, or some internship program. If they do, potentially, there's a new license, or there's a license that they can also apply for to support individuals to come in to serve maximum of 12 months for this type of internship, which is a graduate trainee sort of route. Again, there are several layers of licenses that need to be looked at in several layers of different scenario. But what about if you don't want this sort of graduate training license because you have a training plan, but not, it's not that often, you don't want to really maintain that license? Well, we may be able to look at something else, which is called the government authorized exchange. So it's part of the temporary worker route. Effectively, the temporary worker route is sort of split into several categories, one of which is internship, right? So there's language, there's all of that type of stuff. But essentially, you have a third-party sponsor, which is authorized by the Home Office already, right? And for internship, so people would have probably heard of BUNEC or something along those lines, and they are sort of the sort of GAE approved sort of sponsors as well. Again, in terms of internship, generally it's up to 12 months that an individual can come in, so they can sort of look at that. Again, we are looking at whether they're paid for these type of for graduate trainee, for example. I talked about there's a minimum salary, there's a minimum skill. For the GAE option, usually it's designed for internship side, it's usually for graduates. So we're looking at minimum wage. So Asmat has touched upon that, so meeting the UK basic rules that we can send these individuals over. Each sort of authorized sponsor, you're not the one, their scheme would identify certain elements that needs to be met. And those are the elements that will need to be met, which is do you have a training plan? Do you have a training schedule? What are you paying? What's the vacancy looking like? Is it a super role?
I think that would probably exist. I'm just stepping in because French companies who have interns as such, they are under an internship contract with the school. It's part of their training program. So that would already exist as such, but they would just like them to probably, in Madame Dupont's case, include the internship to be done in the UK rather than just in France.
Absolutely. And the key point here is it a supernumerary role? Are you trying to fill a vacancy? Because if it is a vacancy,
Yes,
then we need to look at the skilled work and so on. But if you're not, then we can potentially look at, again, a lot to discuss with Mrs. Dupont. I think it's a huge project that they need to
she certainly does have a huge project. Tristan and Esmat, and Tristan, perhaps you first, because I know that you can't stay with us too much longer, unfortunately. If Madame Dupont is thinking about transferring these employees, should she be also thinking about perhaps putting them onto a UK employment contract? I mean, Tristan, from a French perspective, what would you be saying here? And then Esmat will be able to tell us about the UK.
Well, I think this depends of the long-term project. To go to a local contract, this implies that you are in the logic of expatriation and not for a temporary mission. So what I would suggest is maybe for start to let the employee submit it to the French labor law for a maximum duration of 24 months, because you cannot second employees in the UK for more than 24 months. So this can be like a test period, just to make sure that the employees want to stay in the UK, that they are well and everything is right. And then after this test period, maybe to put them on the local contract with the local entity in the UK. But for the first months, I think this would not be well accepted by the employees, because Asmat will maybe correct me, but the French labor law is very, very protective to employees, and even if there are a minimum of guarantee in the UK, I would doubt that this minimum is more in favor of employees than French law. So basically, regarding French employees, they would be very, very worried about going
it. Yes.
Before
you leave and before Esmat just comments, I just wanted to know, could you, without terminating their French employment contracts before moving them onto a UK employment contract, if Esmat thinks that that's going to be advisable, could you just suspend their employment contracts in France with an annex saying that during the period they're on an assignment in the UK, it is suspended, but they would always be considered as French employees when they move back to France, or that is not going to be authorized?
Yeah, this is possible. You can also offer like a guarantee to employee if their trip, business trip or work in the UK is not going well, that you guarantee them to get back their job in France, depending on the condition negotiated. But yeah, you can negotiate lots of things with a guarantee to hire back the employee after the suspension period. So this is usually done, especially when the employee go, maybe not in the UK, but in other countries like Africa or Middle East. This is usually a guarantee that employee require.
Esmat, what would you have to say? Thank you, Tristan.
So yeah, Tristan is right that generally UK labour law is less favourable to the employee. And so I can totally appreciate his point of view that the employee is likely to want to stay on their French contract. I think it really depends on the length of stay and whether they're habitually working in the UK, because I mean, if they're habitually working in the UK laws will apply anyway, and it can be quite confusing for both parties where there's two sets of laws applying, two sets of labour laws. So are they bound by the French law? Are they bound by the English law? And essentially, if they've got that French contract still, they're going, both are going to apply. So if it gets to that stage where you've got somebody who is going to be habitually working in the UK, so they're coming over for a considerable amount of time, and we'd probably say that if they really are going to be working in the UK all that time, probably from 9 months to a year would probably be habitual working. And so in that situation, for the employer, it's probably going to be better to get them on a UK contract, to suspend that French contract and get them on the UK one, so that there's then just one set of laws applying. But yeah, I think the employee is going to probably be resisting that on the basis that all of their rights are likely to be better in France.
Right. Now, tax, this time around, there might be some corporate tax implications that Ashley and Cedric, I would like you to comment on, please. And also, how should they manage the employees' income tax filings in the UK, in France? I mean, I know you're going to say it's going to depend what time of the year they're transferred, but let's make it easy and say that they're moving in January. You're on mute, Ashley.
Should I go first? Yeah, this one's very fact dependent, as you said, Fiona, but generally, on the assumption that they're going to be coming over here, they're going to become UK tax resident, they're going to spend more than, half the year here, they'll be UK tax resident for sure. If you spend more than 183 days, that's the default position. They're going to be subject to UK taxation on their employment income, potentially on the 100% of their employment income, unless they're working in and out of the UK, which might be slightly different, might get some relief there. So for a start, there's going to be, the UK is going to want them to file a UK tax return and report that income if they're UK taxable on it. There's a question then, Mark, with Cedric about, if France still taxes too, and who has the primary taxing rights and all that sort of thing. But I think it'd probably be the UK if they're working in the UK. You have, if they go onto a local employment contract, it gets more complicated for the UK employer. They have to PAYE system, pay as you earn. So if the UK employer, UK company pays them, you have to deduct tax and potentially national insurance every month. That's a legal obligation. They have to do that if the UK employer is paying, even if they stay on a French contract. But there's what we have what we call host employer rules, and so the subsidiary could be what we call a host employer, which throws the pay as you earn obligation back onto the subsidiary as well. So there's definitely pay as you earn obligations to navigate for the employer. If the UK employer is paying the salaries, should be getting corporate tax deduction for that. Social security again is complicated. It just depends on the fact pattern, but unless they're still working in France, or unless they're coming over, unless they're still employed by France and only coming over for less than 24 months, the social security could shift to the UK. So you have a UK obligation as opposed to a French obligation, but that's, you know, all caught up in the, the post-Brexit, the trade agreement that's covered by, which you have to step through and just look at each person's facts in terms of can social security remain paid in France, or does it shift to the UK? So you just have to look at what we call a detached worker rules and the mixed state worker rules, which are quite complex. So yeah, lots to consider, I think, for the French employer and potentially the UK sub, and if that becomes the employer as well.
Cedric, something to add in here?
Yes, I can add for the individuals that are transferred, they need to be very clear about the fact that they're transferring tax residency, and it implies in France to declare it to the French tax authorities, to notice them about the change of residency. And it would imply for the first year, the year of the transfer, to submit two tax returns in France, one as a resident and another as a non-resident. And following that, what we can say is that they remain taxable on French source income. So, well, it should not be related to the employment, but I still mention that if they have any French source income, such as a real estate from France, they would still need to submit each year a tax return. And another thing that may apply, notably for managers or director, it's what we call the exit tax. It's only on capital gains on shares. So if an employee has some shares, it's very important to know about the exit tax, because you can have a deferment of the payment of the tax on capital gains, but only if you submit a tax return 3 months before the transfer. So it's very important to know it, even if in most cases it would not apply to most employees. It's still important to know that.
Thank you very much. I see that there are two questions that have come up in the chat. Antonio, one of the questions is, do we need a working visa in pluri-activity?
Sorry, can you clarify that question?
So the question is coming from Nguyen, and it says, hello Tristan, but I think it's because it's visa, it's actually Antonio. Do we need a working visa in pluri-activity? Maybe if you can't answer that directly, the chamber will send you the question with the email address, if you prefer.
Sure, yeah, I think email might be good.
Okay.
I assume you mean different types of activities is what
I'm assuming that as well.
Yeah, so really, so we have to look at, obviously, whether it's a business visit visa or whether it's a work visa. So if it's assuming it's a work visa, then if it's under sponsored route, you can only be sponsored by the sponsor to which sponsors you. So you can't just run around. There are some exceptions, but you generally have to work for the employer to which, or work for the company to which has sponsored you. Now, in the case, and I think if that question came up during the sort of service supplier sort of talk that we were discussing, yeah, then basically you can only work on that particular contract at that particular time, right. Which means you can't just sort of switch around.
Thank you. And please, if the question wasn't clear, I'm sure that the chamber will be able to put you in contact directly with Antonio.